Almost 3 years ago, a group of consumer attorneys and activists from across the state of Florida traveled to Tallahassee to defeat efforts by the banking industry and their friends in the Florida legislature to turn Florida into a non-judicial foreclosure state. I'm happy to report that, of course, we defeated those efforts, but here we are 3 years later, and we're still in a bruising and desperate fight. During the 2012 legislative session, representatives on the House side and on the Senate side are considering legislation which would dramatically affect the rights of all citizens across the state of Florida. This is a desperate fight we're in to protect the rights of citizens all across the state, not just folks that are in foreclosure, but everyone. It has become apparent just today what the real objective behind the legislation is. And that is an amendment to the bill that currently exists, which would strip away the rights of homeowners to ever challenge to get their home back after the bank uses whatever tactics they want to steal their home. I've posted previously the exact language, and I'll append that to this particular blog post, but I want everyone to focus very intently on this language that will allegedly be amended into the bill next week. What the language says is finality of foreclosure judgment. Why this is so important is you have to understand that the only real bargaining power, the only real strength that we have as attorneys to challenge the improper conduct of the banks is the threat that if we catch them doing real wrong, we might be able to put you back into your home. But the language that's being amended onto this bill would eliminate that right for homeowners. Now, if you have a home, let's say it's a family homestead that has a house on it that you were born in, or a special lake or stream or something through it, and the bank used any tactic, any lie, any cheat, any steal, forgery, fraud, whatever they did, but if they did that and they were able to get a final judgment of foreclosure, no matter how bad the conduct is that you were able to demonstrate, you would never be able to get back that home. This is a watershed moment in our state's history, because what we're doing, if we allow the legislature to amend this language into the bill, is to destroy private property rights that have existed in this country from the beginning of our time. You see, property is unique and specific. That home that you were born in, that special piece of family farming land, cannot be replaced with any other piece of land, and it certainly can't be replaced with any check that you might get long after from some bank. And yet that's exactly what this language seeks to do. It would remove your ability to go back and get that family land, to get your home after it's been stolen from you by the banks, if they are successful in drafting this language in. Now, this language, I think, gets to the heart of what's really going on with this piece of legislation. I'm hearing that the banks are not particularly satisfied with the bill as it exists, and the condo associations don't particularly like it. So we're having to wait and see what's going to come out of this next committee meeting. The travel of this bill is next week. It's the week of February 16th. The House version of Kathleen Passidomo's Unfair Foreclosure Act, that's Bill number 213, will go before the House Judiciary Committee. It's at this committee, sort of the last stop before it goes on to the full House floor, when the final changes will be put into this bill. And so this is why it's most critical that everyone contact all of these members on the House Judiciary Committee and urge them not to support this Frankenstein ugly bill. And I call it a Frankenstein foreclosure bill because it's got so many pieces thrown into it that, again, I don't think the original proponents of it would really support it in its current form. Critical to note as well that the Senate version of the Unfair Foreclosure Act is being drafted even as we speak. I'm told that Senator Jack Latvala from right here in Pinellas County is drafting the Senate component of this, and really what comes out of that Senate drafting is going to be most important. This Senate draft bill should come out sometime, I guess this week, maybe Monday. But what that bill looks like is critical, because how close that bill is to the House version of what's coming out will speak volumes about what's going to happen in this state with foreclosures for decades to come. Make no mistake about it, as we've seen with the settlement that was announced by the Obama administration and attorneys general from across the country, there is no one out there that is elected that's really standing up and representing people. The Obama administration's settlement with the banks, signed off on by attorneys general from across the country, including Florida's attorney general, is an absolute disgrace. It really bothers me that press doesn't do basic math. We've got the Attorney General of California claiming $18 billion in benefits for her state. We've got Florida's Attorney General claiming $8 billion in benefits for our state. By my rough math, that's more than what they're proposing as the final settlement amount, which brings us to one of the most important points of this abused settlement, and that is, years ago, Bill McCollum announced, another attorney general, announced a settlement with Countrywide regarding their improper loan practices, in much the same way that we have this attorney general settlement. In the headlines, blasted all across the country, was Countrywide agrees to pay $5 billion. Now, I asked recently, did anybody ever look back to see whether any of that money was collected? Nobody really had. Once the papers had reported that there was a settlement agreement, $5 billion, that was cut and pasted from the press releases announced by Bank of America, Countrywide, and the attorneys general, the press failed to follow up on whether any of that money was actually paid. Well, that's the same thing with this federal AG settlement. Once the newspapers get done with these headlines, $26 billion to be paid by the banks, nobody really follows up to see whether any homeowner will ever benefit from that. And I would submit to you that even if they doled out all $25 billion tomorrow, it wouldn't nearly do enough to, number one, help consumers, number two, stand up for the principles of following the law, and number three, provide some sort of penalty for the banks for engaging in grossly abusive process. And let's be clear about what this is. The banks and institutions have been permitted to get away with grossly abusive processes that are a violation of our fundamental notions of due process and justice. Let's again be clear what this is. The banks have been permitted to engage in lies, fraud, forgery, and other abuses, and they're walking away scot-free. Another key component to look at this bill, or the settlement agreement, is, are the banks actually paying anything from it? And that's very much a mixed question. One of the frustrating things about this bill is that we are guessing for the most part. They negotiate the terms of this settlement in secret, in private, with the bank's attorneys and lawyers and lobbyists, behind closed doors, with the attorneys general, with their own banks, with their own attorneys and lobbyists and press people. And they announced this deal yesterday, and yet you and I, the victims of this deal, still don't know what the terms of it are. That is repugnant to our basic notions of what this country was, a government of the people, by the people, for the people, all that nonsense, that delusion we live under. If that were really true, that this government was working for us, or that you and I, as normal, everyday citizens, voters, had any input or say-so into what was happening in our government, we would know what the terms of this settlement are before our attorneys general signed on to the bottom line with the banks. But the evidence that this is a government by the banks, for the banks, of the banks, is the fact that this deal is inked, it's signed, and then it's thrown at us as if we are serfs in some king's kingdom. We don't have any input into it. Terribly, terribly frustrating. We've been sold up the river once again, and nobody's doing anything about it. Finally, and most importantly, I desperately want to encourage everyone to travel to Tallahassee next Thursday, February 16th. There will be buses coming up from different parts of the state, but whether you drive there or walk a horse there or hit on one of these buses, it's just so critical that you come to Tallahassee, you make your voice heard. I recognize that it's difficult, it's expensive, it's time-consuming, but you have to understand that the banks and the institutions have teams of lobbyists that are there fighting against you. The legislators are listening largely to these lobbyists and their banking friends, and we are not represented. So there will be a small band of consumer lawyers who are taking the time out of their practices to go up and fight for you and for consumers. I hope that you would support those attorneys and consumers that are up there doing it, and that all of you will share with your friends on Facebook and email and everywhere else the fact that there is this rally and tally February 16th, that's Thursday. I hope to see every one of you there.